Hello friends and welcome to Unacademy Articulate. I am Joycey Joy and today we will be discussing about Patents Amendment Rule of 2020 and this is Current Economy of the Day series. So let's get started. So this is the combo offer that Unacademy is providing. So the combo offer, it comes with your GS subjects plus your optionals. So combination of general studies and optionals. You can either go for a plus subscription and the optionals, or you can go for iconic subscription and the optional. So this is the combo offers available, either your plus subscription and the optionals or your iconic subscription and the optionals. So you can go for any of them and we are providing offers as well. So this is the subscription fee. If you are going for a iconic subscription and the optional, so iconic subscription and optional, 12-month subscription fee would be 88,705. For 24 months it is 1,31,510. 36 months it is 1,67,220. And if you are going for a plus subscription and the optionals, 12-month subscription fee is 70,103. 24 months it is 99,680 and 36 months it is 1,21,200. You can also use my referral code, which is Joycey10, JOICY10. This is my referral code and you will be getting an extra 10% discount. So using this referral code, you will get an extra 10% discount. And this is regarding iconic subscription. So iconic subscription, we are soon to announce a price hike in the iconic subscription, and these are the features of the iconic subscription apart from the plus features. So these features are available for your iconic subscription, and this is over and above the features available on plus platform. You will be able to connect with your personal coach, that is, you will be provided with a personal mentor. There will be a mains test series along with evaluation. You will get a customized study planner, study booster sessions, high intensity workshops, daily answer writing, and also daily content to accelerate your preparation. So if you are already a plus subscriber, you can upgrade to iconic, or you can otherwise join the iconic subscription. And if you are getting either the plus subscription or the iconic subscriptions, you can use my promo code. This is my code, that is Joycey10. This is my referral code. And you will get an extra 10% off on the subscriptions that you make. Even for the combo offer, you can use my code Joycey10, JOICY10. Now we are discussing about Patent Amendment Rules of 2020 today. So let's begin with the current affair. Let's see what is in the news. Central government has recently published the Patent Amendment Rules of 2020, and this rules amends the format of a statement that patentees and the licensees are required to annually submit to the patent office, disclosing the extent to which they have commercially worked or made the patented inventions available to the public. So this amendments, that is the Patent Amendment Rules of 2020. So what amendments has been brought? The format of the statement has been amended. What statement? The patentees and the licensees, they have to annually submit a report or a statement to the patent office. So this statement is regarding the extent, or they have to disclose the extent in which they have commercially worked or made the patented inventions available to the public. That is how much they have given the patented inventions to the public. That is what they have to disclose in the statement. Now the format in which the statement has to be shared with the authority, that is the patent office, has been changed. Recent amendment to the form was made pursuant to a PIL filed by Shamnath Bashir before the Delhi High Court in 2015. So the recent amendment, that is the amendment in the form or the statement. So the recent amendment to this form was made because of the PIL filed by Shamnath Bashir before the Delhi High Court in the year 2015. Amendment has significantly watered down the disclosure format, which could hamper the effectiveness of India's compulsory licensing regime. So, amendment has watered down the disclosure format, and this could hamper the effectiveness of India's compulsory licensing regime. Let's see how. First, let's see what are IPR. IPR are intellectual property rights. So, the intellectual property rights or the IPR, it gives the creator of the intellectual property an exclusive right. That is, it belongs to a particular person. The right of using an intellectual property or the right of ownership of an intellectual property, it belongs completely to the creator. So creator gets an exclusive right over the use of his or her creation for a certain period of time. Under the intellectual property rights, the creator gets the exclusive right, that is complete right over the use of his creation for a particular period of time. The rights given to persons over the inventions, literary and artistic works, symbols, names and images. So, what kind of works get these rights? So, these are the kinds or the types of work which get the right. Inventions, literary works, artistic works, symbols, names and images. So, all these intellectual works can get the intellectual property rights. The importance of intellectual property was first recognized in the Paris Convention for Protection of Industrial Property. So, it was the Paris Convention for the Protection of Industrial Property, which was held in 1883, which realized the importance for the very first time, the importance of intellectual property, and the Berne Convention for the Protection of Literary and Artistic Works in 1886. So, these were the first two conventions which for the very first time recognized the importance of intellectual property. The WIPO is World Intellectual Property Organization. WIPO, it is a body responsible for promotion of the protection of intellectual property rights throughout the world. So, WIPO or the World Intellectual Property Organization, it is a body which is responsible for the promotion of protection of the intellectual property rights throughout the world. Various subject matters of intellectual property in India. It includes, in India, these are the various subjects that are covered under the intellectual property rights: copyrights, patents, trademarks, designs, geographical indicators, plant varieties, superconductor chips, integrated circuits, traditional knowledge, biological diversity. So, these are the various things covered under intellectual property in India. So, all these can be considered as intellectual property. A patent is granted for an invention, a new product or process involving a novel step and capable in commercial application. So, patent. The provision of a patent, it's granted for a particular invention. So, it's granted for an invention, for a new product or a process which involves a novel step and capable in commercial application. Patents are granted for almost 20 years and on any new product or process to original creator. So, this is very important. Product patent and process patent. Product patent and process patent. After the expiry of 20 years, such patents expire and generic industry can exploit what was once patented. So, after 20 years, what happens? The patent, the time or the duration of or the validity of the patents expire, and after that the generic industries can exploit what was patented. That is, everybody can get the right to produce that particular commodity or the product. India followed a process patent regime for long before and turned to a product patent system for food, chemicals and pharmaceuticals. So in 2005 we shifted to a product patent system for food, for chemicals and for pharmaceuticals. But earlier we used to follow a process patent regime. So we earlier had followed a process patent regime. The National Intellectual Property Rights, the IPR policy of 2016, it's a vision document to guide future development of IPRs in the country. So, National Intellectual Property Rights Policy of 2016. This is the vision document that will guide the future developments of the intellectual property rights in the country. The DIPP, now it is DPIIT. So, Department of Industrial Policy and Promotion, the Ministry of Commerce, the Government of India has been appointed as the nodal department. So, DIPP is the nodal department to coordinate, guide and oversee the implementation and future development of IPRs in India, intellectual property rights in India. The Office of the Controller General of Patents, Designs and Trademarks, or the CGPDTM, is the body responsible for India Patent Act. So, Office of the Controller General of Patents, Designs and Trademarks. This is the body responsible for Indian Patent Act. Now coming to Patents Amendment Rules of 2020. First one, it streamlined the requirements related to filing of Form 27 and submission of verified English translation of priority documents which is not in English. So Form 27, what is this form about? It is about disclosure of how the patented product has been used for the general public. The patentee gets the flexibility to file a single Form 27 in respect of single or multiple related patents, and where a patent is granted to two or more persons, such persons may file a joint Form 27. So a patentee gets the flexibility to file a single Form 27 in respect of single or multiple related patents, and where a patent is granted to two or more persons, such persons may file a joint Form 27. The time available to patentees for filing the Form 27 has also been extended to 6 months against the current 3 months from the expiry of the financial year. So now more flexibility is being given. Time available to the patentees for filing this Form 27. This has been extended. So earlier it was 3 months. Currently it is 3 months. Now it's extended to 6 months. So now 6 months will be given. If the priority document is available in WIPO's digital library, WIPO is World Intellectual Property Organization. If the priority document is available in WIPO's digital library, the applicant would not be required to submit the same in the Indian Patent Office. So this is another amendment or another change that has been made. If the priority document, if it is available in WIPO's digital library, then the patentee need not file it in the Indian Patent Office. Now we will also discuss about compulsory licensing. Compulsory licensing is a license or an authorization issued by the government to an applicant for making, using and selling a patented product or employing a patented process without the consent of the patentee. So, compulsory licensing. Compulsory licensing is actually a license or it is an authorization. So it's either a license or an authorization. It's issued by the government. Now for whom it is issued? For the applicant. And if the compulsory licensing is issued, then the applicant can make, use or sell a patented product or employ a patented process without the consent of the patentee. So what happens when a person gets a patent? The person who gets the patent or the patentee gets the exclusive rights to use that product or the process. But in case of compulsory licensing, this is a kind of exception. So it's an exception in the sense that the government is giving the right to use the patented product or make or sell this product to somebody else, to a third party. So this authority or the license given by the government to a third party to use a patented product or a process is called compulsory licensing. So this is an exception for patent. Chapter 16 of the Indian Patents Act 1970 and the Agreement on Trade Related Aspects of Intellectual Property Rights discuss compulsory licensing. So these are the provisions. Which discuss about the compulsory licensing. Compulsory licenses can also be issued suo motu by the controller of patents. So suo motu means without receiving an application. Without receiving even without receiving an application, the controller of patents can issue the compulsory license. In what situation? If they feel that there is an extreme emergency or a national emergency. To a notification issued by central government if there is either a national emergency or an extreme urgency or in cases of public non-commercial use. I'll give you an example. For example, a medicine. A medicine has been given patent. But the government feels that this medicine is of urgent public importance, that this is going to help a lot of people. Now, for example, a COVID vaccine. I'm just giving you an example. Suppose a person has developed a COVID vaccine and has acquired the patent for the same. But a situation has come up such that the COVID vaccine has become a necessity for the general public and the COVID-19 is spreading on large scale. So in this situation, what is important? The patented person or the patentee can commercialize it and increase the profit margins. So it is of utmost importance for the general public that they get access to these vaccines. So in this situation, the government can issue a notification for compulsory licensing. And in this situation, even though there is no application for compulsory licensing, the government can issue compulsory licensing suo motu. That is, the controller of patents can issue the license suo motu. That is, by their own will. Okay, I hope you got this point. The application for compulsory license can be made any time after 3 years from the date of sealing of a patent. So application for a compulsory licensing can be made any time after 3 years from the date of sealing of a patent. So these are the points to be remembered about patents and compulsory licensing. So that is all from my end for today. See you again tomorrow. Bye bye and take care.